We're all set? Okay. Shut off phones. And mute their.
And mute the laptops if they're allowed.
Just shut this up. Good afternoon to the members of the Right to Know Advisory Committee and members of the public who might be joining us. We are about to begin the full Right to Know Advisory Committee meeting scheduled for Wednesday, December 1st, 2021. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, and I chair this committee. And I'm going to begin with introductions from committee members, starting with those who are physically in the AFA room today in the Capitol, beginning with Judy Meyer.
Thank you. Judy Meyer. I represent Maine's newspaper publishers.
Thank you. Jim?
Jim Campbell. I represent a statewide group of individuals and organizations committed to access to government information.
Thank you. Senator Carney?
I'm Ann Carney. I represent Senate District 29, and I am here as a legislative member.
And Suzanne?
Suzanne Goucher, representing broadcast interests.
Thank you and welcome. Linda?
Linda Clancy, representing the Maine Press.
Thank you very much. And I am going to now go to those participating remotely and call on you as you appear on my screen, beginning with Eric Stout.
Eric Stout, a member with background in information technology.
Thank you, Eric. Linda Cohen.
Linda Cohen, representing local government.
Amy Beveridge.
Amy Beveridge, representing Association of Broadcasters.
Thank you and welcome. And Justin Chenette.
Thank you, Representative. I'm Justin Chenette, and I represent members of the public.
And Julie Finn.
Good afternoon. I'm Julie Finn, and I represent the Maine Judicial Branch.
Thank you for being here today. Kevin Martin.
Kevin Martin, representing state government interests.
Thank you, Kevin. And Christopher Parr.
Hi, Chris Parr. I represent law enforcement interests.
Thank you. And we are also being assisted today by our staff from the Office of Policy and Legal Analysis, Colleen McCarthy-Reed, Peggy Reinsch, Rachel Olson, and Anna Broom. Thank you all for being here today. And we will turn to our agenda. And the first item on the agenda, I'm sorry. Oh, I'm sorry. I've done this twice and I can't blame it on my eyeglasses this time. And I see we have one other committee member, Vicki Wallach. If you could just introduce yourself.
Can you hear me?
Yep.
Hello. Thank you for having me. Good to see everybody.
Thank you. And we're also joined by Kate McBride from the Maine State Archives. Thank you for joining us today. And we will be joined by the Right to Know Ombudsman, Brenda Kelty, but I believe she had a call at 1 o'clock, so she is going to be a little late. And I see some members of the public. We will have an opportunity for members of the public to weigh in at the end of today's session. So again, turning to the agenda, I think I have everybody that is here. The first item on the agenda is to review and approve letters to the Public Access Ombudsman and the Maine Municipal Association requesting data on public records requests completed in 2 hours or less. Should I turn this over to you, Peggy, or to Colleen? Rachel, okay.
It's actually going to be me from remotely.
Okay.
I believe, and Peggy will correct me if I'm wrong, I think those members who are in the room have received paper copies of the 2 letters. And this is my first real hybrid meeting from away. So would you like me to share the screen for the two letters as well?
Sure, if that's something you're able to do, that'd be great.
It is. Okay, so you should be looking at the first letter. So at the last meeting of the full Right to Know Advisory Committee, we discussed fee waivers. And a lot of the conversation around fee waivers centered on the changes that were made in recent legislation last session to the amount of essentially free time that an individual would get when requesting access to public records. That was increased from 1 to 2 hours. And so a lot of the conversation around fee waivers had to do with how the change from 1 to 2 hours would impact the number of fee waiver requests that an agency would get. And so I believe last year and during conversation around the LD, data was provided by the Maine Municipal Association and is also tracked by the Public Access Ombudsman and for their annual report on the number of fee waiver requests they receive. And the committee expressed a desire to see how these changes to this amount of time would impact fee waivers before moving forward with this topic. So 2 letters were drafted, one to Brenda Kilty, the Public Access Ombudsman, and the other to MMA to request that they collect this data for the committee. I have these 2 letters available. You can see the first one here to Brenda Kilty. I'm happy to go through this more specifically. These were sent out in advance. And then also to MMA. I'm happy to leave one on the screen more than the other or to switch back and forth. Let me know how you'd like me to proceed.
Thank you very much for that. Are there questions from committee members regarding the letter to Ms. Kelty and to the Mr. Goldberg at Maine Municipal Association? Not seeing any. If I could have the full screen back so I could see. There are any questions from members of the Right to Know Advisory Committee regarding the 2 letters, please raise your physical hand. And seeing none, I'm sorry. I've got to learn to look to my left.
Both letters say that the committee wants a report back by December 1, which is today. So I assume you're going to change that
It's
date.
next year.
Oh, 2022.
I made the same mistake, both letters.
Well, and I could easily have made that mistake. I may have before asking someone to review it. So.
No, I see it now. It's 2022. I was hung up on December 1st, but I see now.
We are that efficient.
Yeah.
Okay, are there additional questions? Christopher Parr.
Thank you. Yeah, I do have a question. So at what point are agencies supposed to be starting to collect the information? Is that the turn of as of January 1st? Because we usually track annual data. So if the report back is December 1st of 2022, that would be almost a month of data that wouldn't be captured. And I don't know if that matters, but I would just point that out and ask for clarification on that.
Well, I think the intent was, Rachel, correct me if I'm wrong, was to get as much information as the committee's hand as possible by next December. So if there's a cutoff of 1 month, it will capture at least all of the time period before that. Is that accurate?
Yes, that's accurate. December 1st was chosen purely so that this information could be in the committee's hands during its work's next interim. And I'll just, the data exists, so it would be possible to probably pull out the data from this month and last month of 2021 as well if we wanted to try to get a full year picture, although I believe that the legislation that increased the fee waiver probably only took effect in October the 18th.
Right.
So it's relatively new change, but I would guess we could pull out the data, but again, that would be sort of up to the agencies on if they're able to take December, the current data from December of 2021 and bring it into that annual data. So my guess is we'll go without the month probably.
Thank you. And the goal here was to get as much information from agencies and MMA about how the new statute is working so that we can determine whether or not it needs to be revisited and or amended in 2023. So thank you. Are there any additional questions regarding the letters? Mr. Stout, sorry, too many things going on here for this mind.
Yeah, so I would suggest before we conclude on the date, when Brenda is able to join us or weigh in, because as Chris noted, he's the FOA coordinator for the Department of Public Safety, as well as a staff attorney. But agencies take their instructions from Brenda as far as a call for data. And so if there's a change, it might be, they keep spreadsheets and different ways of reporting. So it might be cleaner to start that as far as the state agencies, January 1st, because they're going to react to a call from Brenda as to what data she wants and when she wants it. So I would just suggest, letting Brenda weigh in on what that should say as far as the time frame. And my other thought was, do we want to wait until December 1st? Because this year we started mid-November. So why wait until we're almost done to get that data? Maybe back it up to November.
Okay. As to the first question, we'll have to wait for Brenda to join us. As to the second question about when the committee would like this information next year, are there others who want to weigh in on the date that they think we should have that information before the full committee? And Eric's concern is that we're going to get this perhaps 2 weeks before our final meeting in 2022. That might not present us with enough time to digest that information. Is that accurate, Eric? Okay. Other views on this? Jim?
Given that Thanksgiving and that holiday is, the week before this, it might, and there probably wouldn't be much business being conducted there anyway. It might make sense to make it the Monday of Thanksgiving week or something. And I don't think we'd lose much data, but we would have it a couple of weeks sooner to look at.
Okay, so there's been a recommendation to change the date to the Monday before Thanksgiving in 2022, and I have no idea what that date is, but I'm sure there are people with watches and calendars and Googles that can tell us that. Other thoughts on the date? I mean, I do think it makes some sense to have it with enough time to digest it. Senator Carney?
Yeah. How would it feel if we did a specific time frame like December 1, 2021 to September 30th, 2022, with the information being due November 1st, 2022?
So
something like that. It's a little less information, but it's a discrete and easier to respond to requests.
So you're saying December 1, 2021 until the end of September?
The end of September.
30 days has November. That would be the 31st?
30th.
30th. I forgot my song.
I sang it in my head prior to pushing my button. And then have the information due November 1.
Okay. Okay, so there's been a recommendation to change to have the reporting period from December 1st, 2021 through September 30th, 2022, with the information then transmitted to the Right to Know Advisory Committee by November 1st, 2022. And Eric, do you still want to wait until we hear from Brenda?
Yes, and I would, since this is already the 1st of December and the letter hasn't gone out and people need time to shift gears, I would just suggest it's cleaner to start with January 1st as a new reporting period. Being a longtime bureaucrat, people need time to be able to adjust their reporting, processes. But yes, I would defer to Brenda to see what she thinks, but I think it's cleaner to just start January 1st. And it also gives people notice instead of jumping them in the alley this afternoon.
Okay. Well, regardless of the date that we choose, it appears that we need to wait until Ms. Kelty arrives so she can address your original question, Eric. So I will entertain a motion to table this and we will return to it when Ms. Kelty is available.
So moved.
Motion made by Ms. Goucher to table. Do I have a second?
Second.
Seconded by Mr. Campbell. Motions to table are not debatable. All those in favor? Thank you. The motion is approved. We will revisit the letters when Ms. Kelty is able to join us. I'm sorry, I'm looking at the wrong agenda. The next item on the agenda is the report of subcommittees. And the first being a report from the Public Records Exceptions Subcommittee. And I will call on the subcommittee chair, Chris Parr.
Thank you very much. Appreciate it. We had another tremendous meeting. And I have a great prepared summary that was not prepared by me that I'm going to rely on here. We discussed, there's also going to be some recommendations as I go through this document that I'll be making and will want to probably act on at times. At our last meeting, we discussed the following topics. First, we reviewed the exceptions in titles 8 through 12 that were tabled from 2020. This is work that I think we had started at our meeting even before the last one. We completed a review of 22 of the 26 exceptions. And there was a chart that I think was disseminated to the committee that shows those exceptions. We recommended that no changes to those 22 exceptions be made. 4 of the exceptions have been tabled for review at our next meeting and probably our last meeting on December 10th. So our first recommendation as a subcommittee is that the full advisory committee accept the subcommittee's recommendation that no changes be made to the exceptions reviewed in titles 8 through 12, except for reference numbers 2020-4, -11, -44, and -54.
And I'll just clarify, so if you look,
Thank you.
the list of those is on the pink piece of paper that folks that are in the room have, and I'm happy to share the screen for folks who aren't here. If they want to see the list of those exceptions in titles 8 to 12 that the subcommittee is recommending you accept with no changes. So.
Would members of the committee prefer to have the list shared? And I know we all have a copy of it. Was it sent electronically as well?
I don't think so. So let me share.
Sure, thank you.
Compilation of the two charts. Yeah. So this is pulling up now is what's pulled up now on the screen is what Mr. Parr was just talking about, which is the first set of exceptions that the subcommittee reviewed with regard to in titles 8 to 12. And this is the list of those 22 of 26 exceptions that the subcommittee recommended with no change. And there are 4 that have been tabled that we're still working on. But this is the list of the 22 in that batch of the exceptions being reviewed by the subcommittee.
Thank you. Are there any questions from committee members? Seeing none, do we need a motion here, or are we just accepting the report of the subcommittee?
I think if you want to, there are some other exceptions in the next batch that the subcommittee is recommending with no change. So you may want to wait and go through and do them all at once. And then there are 2 other recommendations that you probably would want to have motions for, but you could probably do the exceptions all in one as opposed to 2. So could wait just a minute, and then I think Mr. Parr will talk about the ones
Okay.
in 13 to 19A and maybe do those collectively.
Thank you.
Yeah.
All right, shall I carry on?
Yes, please.
All right. And Colleen, you can call me Chris. You don't have to call me Mr. Parr. All right. Next, we reviewed exceptions in Titles 13 through Title 19A. There were 43 exceptions identified for review. The subcommittee completed a review of 36 of those exceptions. We agreed that it was not necessary to review 7 of those exceptions, numbers 11 through 17, that were contained in Title 15. And that's because they related to juvenile records exceptions that were recently enacted and that were vetted during the last legislative session by the Judiciary Committee. And we have recommended that there be no changes to those exceptions. Sorry, Colleen, I want to make sure. Oh, number 1 to these exceptions, numbers 1 through 10 and numbers 18 through number 43.
I'll just share this quickly just to show you I listed them out separately here for you in the screen. They're all the exceptions within Title 13 to 19A. And again, the subcommittee is recommending no changes. This is the list of them. They relate to court records and procedures in Title 14 generally. Title 16 relates to some information in criminal history record information. There are 2 provisions in 17A related to information related to crime victims. The provisions in Title 18C relate to probate, court, and guardianship issues. And then a number of provisions in Title 19A relating to divorce proceedings, child protective proceedings, and other judicial proceedings. So those are all, this is the list. And again, the subcommittee reviewed them with the help of the questionnaires from the agencies or other affected stakeholders are recommending no change.
Thank you.
Thank you. Are there questions from committee members? And I confess, Colleen, I am a little bit confused because we have additional material in pink. Is the time, do we review that now, or?
Those relate to the additional recommendations that Chris is going to go through. So the first 3 pages of the pink relate to the exceptions review.
Okay, so that's a draft being recommended and we need to vote on whether to accept that draft. So I would entertain a motion to accept the draft. Senator Carney?
I move that we accept the recommendation that, I just need to put my glasses on, that no changes need to be made to the exceptions listed in pages 1 through 3 of the report of the Public Records Exception Subcommittee dated December 1.
Thank you. We have a motion by Senator Carney to accept the draft. Do I have a second? Seconded by Judy Meyer. Is there any discussion amongst committee members? Looking for hands. I'm not seeing any in the room nor on the screen. So do we need a roll call? Okay, if you could please call the roll.
Sure. do need a roll call to be consistent with your policy now. So I will call the roll. So those in favor, the motion is to accept the subcommittee's recommendation that no changes be made to those exceptions listed in titles 8 to 12 and 13 to 19A on pages 1 to 3 of the materials provided. So if you're voting in favor of the motion, you'll vote yes. Senator Carney,
Yes.
Representative Harnett.
Yes.
I'm just going to go in my order. So Linda Cohen,
Yes.
Eric Stout,
Yes.
Justin Chanette,
Yes.
Amy Beveridge,
Yes.
Linda Clancy,
Yes.
Chris Parr,
Yes.
Taylor Asen is absent, Jim Campbell,
Yes.
Suzanne Goucher,
Doug Pat.
yes, voting yes. Judy Meyer,
Yes.
Julie Finn,
Yes.
Mr. Bolton is absent, Kevin Martin,
Yes.
and Vicky Wallach.
Yes.
Yes. So that is unanimous of the members present. Thank you very much.
Thank you, Colleen. And I will return back to Chris for the remainder of his report.
Great, thank you. The subcommittee also developed a revised draft matrix that includes a note about the application of Title V, Section 95C, subsection 1, paragraph C, when reviewing proposed or existing public records exceptions. So this is the matrix that can be and is used by the Judiciary Committee and the Right to Know Advisory Committee as part of public exception review, public exceptions that exist or are newly proposed. That matrix could also be distributed to legislative committees when considering public records exceptions, so that there'll be increased awareness that Maine law does not provide for permanent and forever confidentiality. The default treatment of everything in the archives possession is that it's accessible to the public after it's been in existence for 75 years. And that 75-year period begins to run when the file is completed or closed. The subcommittee felt that any policy recommendations to change the archive statute itself should come from state archives directly and not through the Right to Know Advisory Committee. Kate McBrien, the state archivist, indicated she was comfortable with the suggested approach to revising the matrix as we're recommending, as it would help to ensure that the legislature's intent for confidential records does not conflict with Title V, Section 95C, subsection 1, paragraph C, which sets forth that 75-year period. So our recommendation as a subcommittee is that the full advisory committee accept our recommendation that a revised matrix to increase awareness of the archives statutes be used when legislative committees, the Judiciary Committee, and the Advisory Committee are reviewing proposed or existing public records exceptions.
I can pull that up so I can share the screen. So folks.
Thank you.
should be able
Thank
to
you, Chris.
see
While
it.
that's being pulled up, that's the note that's in bold, about
Yes.
2/3 of the way down.
Yes.
And again, my understanding, Chris, is this is just to make people aware. It does not require any action by the reviewing committee. It is just to give them all of the information regarding the records that it is dealt with elsewhere in statute.
Yeah, that's exactly right. It basically would be amending the matrix that's currently used. You're probably, I'm sure you and Senator Carney are very familiar with it when looking at proposed public records exceptions at the very least. This would be added as a consideration to weigh in that balance in making decisions. And it also will raise people's awareness about the existence of that statute, which I didn't even myself know about till recently. So.
Thank you. Does it change the task of the Judiciary Committee as they review these documents or other committees?
No, it's just another factor among the other ones that are listed in the matrix to consider as far as, really it's to bring awareness that if the committee is trending toward thinking that something should be confidential, it's a reminder that this isn't necessarily forever confidential. There is a period, unless the legislature puts language in a statute that says otherwise, that the records, if they end up in state archives custody, become public after 75 years.
Thank you.
And you have to change, you have to turn your computer if you're looking at it. If you're looking at it on the screen, but turn it sideways. But it was the only way the matrix would fit on one page, I think. But it's the highlighted language for those who are looking at it on the screen. And again, it's just really noting the existence of that archive statute so that when looking at these proposed or existing exceptions, it can be an additional consideration. And if there is some reason to maintain confidentiality permanently, then the subcommittee or the Judiciary Committee or the Legislative Committee can take some further action.
Thank you. And if you turn your computer, it readjusts itself, so you have to lie down on the horseshoe. I guess I'm a little, is the person who reviews these all the time. If say the Judiciary Committee determines, well, we want this to be confidential for more than 75 years, that would require statutory action by the committee. Is that correct? And then the full legislature.
That's right. So what would probably end up happening, for example, it's a great question. And we talked about this a little bit. But you would have to put some sort of notwithstanding language, notwithstanding the Title V provision. These records are going to be confidential indefinitely beyond 75 years. Or conversely, you may not want them to be confidential for as long as 75 years. But it does give the legislature that discretion to change that duration. But the default would be the Title V provision. And Kate, I just realized Kate McBrien is on, and she might have thoughts on this as well. So thank you.
Kate, do you have anything you'd like to weigh in on this issue?
I think the only thing I would add is that what this really does is it helps committees to be aware. It asks the question, and it helps the archives to understand the intent of making a record confidential. Is it intended to be forever or not? So often it's just not specified. So we don't know what the original intention is behind it. So it helps to clarify that.
Thank you. So it's really reminding us of the default position, right? Okay. Thank you. And do we need a separate motion to accept this change to the matrix? Okay. I would entertain a motion to accept the recommendation of the Public Records Subcommittee.
So
Senator
moved.
Carney.
So moved.
Motion made by Senator Carney. Do I have a second?
Second.
Seconded by Mr. Campbell. Is there any discussion amongst committee members? Not seeing hands in the room, nor am I seeing any on the screen. I'm sorry, Senator Carney.
Just that I think it's a great idea. It will help the committees with the initial legislation. I think it'll help the Judiciary Committee a lot as well.
And thank you for that. Seeing no other hands, I would ask for the roll to be called.
Okay, great. Voting on the motion to accept the recommendation of the revised matrix. Senator Carney.
Yes.
Representative Harnett.
Yes.
Linda Cohen.
Yes.
Eric Stout.
Yes.
Justin Jeanette.
Yes.
Amy Beveridge.
Yes.
Linda Clancy.
Yes.
Parr.
Yes.
Taylor Asen is absent. Jim Campbell.
Yes.
Suzanne Goucher,
Yes.
Judy Meyer,
Yes.
Julie Finn,
Yes.
Jonathan Bolton is absent, Kevin Martin,
Yes.
and Vicky Wallach.
Yes.
Yes. So that's unanimous of the 14 members present.
Thank you.
Thank you.
And now turning to the final 2 pages, final 3 pages of your report, Chris.
Yes, so this was a discussion that we had that itself was tremendous during the tremendous meeting. It was about standardized language for public records exceptions. And this is going to, I'll be reading quite a lot here as part of my report back, so please bear with me. We reviewed the report submitted by OPLA and the document outlining specific examples of standardized language when drafting public records exceptions based on whether a record can be shared with specific persons or for identified purposes. While the advisory committee cannot bind the revisor's office to such language when drafting legislation, the revisor's office will consider this as strong guidance for drafters. So we agreed with the report's suggestion that drafters only need to include language designating a record as quote unquote confidential. The language does not need to describe a record as not a public record either, alone or in addition to be designated as confidential. There has been some suggestion in the past that there is a difference in the treatment of a record described as not a public record as compared to a record that's designated confidential, but staff had not found any court cases to support that principle or that distinction that some thought was there. Ms. Kelty, the public access ombudsman, noted the confusion when the phrase "not a public record" has been used. Some agencies have used that as a basis for responding to a request for public records with the response, "Well, there are no public records," when confidential records may exist in a manner that affects a requester's right to appeal. Ms. Kelty expressed support for recommending standardized language. References to a record as not a public record is unnecessarily confusing. Records do meet the definition of a public record, but are accepted as confidential and not subject to disclosure. So in that case, just to restate that, there have been responses made in response to public records requests in the past, saying, well, we have no public records. But what Ms. Kelty's point is that, well, there are public records. It's just that they're accepted, but by not being forthcoming about the fact there are public records and just saying there are no public records, the ability to appeal an agency's effective denial is removed because they don't know that there's any records at issue to even file an appeal about. So standardizing the language so that the use of confidential to designate records that would not be subject to disclosure under FOA should be the recommended approach. The subcommittee voted unanimously to endorse the suggested standardized language as drafting guidance and recommend it to the advisory committee. The recommendation does not include making statutory changes at this time. Moving forward, the advisory committee can consider statutory changes to be consistent with the drafting guidelines for standardized language. So our subcommittee's recommendation is that the advisory committee endorse the suggested standardized language as drafting guidance, namely that simply the term confidential be used to describe records that are not that are accepted from the definition of public records, basically.
And I'm happy to, I'll just pull up this quickly, the document quickly to
Thank you.
share. So folks can see it. This is the document that the subcommittee reviewed. And it's really just pulling out some language that was included in the report that our office submitted to the Right to Know Advisory Committee earlier as required by law. So in addition to the suggestion that moving forward, you're designating a record as confidential, that should be the language you use. You wouldn't use, in addition to that, you wouldn't say a record, you wouldn't say it's confidential and not a public record. So would just use that designation, the language of confidential, and then the drafting guidance for future drafters and others when reviewing language. These are some of the examples for how we would suggest to clearly delineate a record as confidential, and then describe the other examples, describe additional circumstances when confidential records may be disclosed and what those circumstances are, whether it may be disclosed with the express permission of someone, whether it may be disclosed to a specific person or for certain purposes. And then these were just some examples of how, or sort of best practices for drafting. And if the recommendation of the subcommittee is that we would share this with the revisor's office and others as drafting guidance, and you also could use it moving forward as you look at proposed and existing exceptions to see if they sort of conform with these suggestions.
Thank you. Are there questions for Colleen or Chris on this? Judy?
So are any new confidentialities being created, or is this just massaging the language? I specifically, on page 7, paragraph 7, making the request for funds for expert investigative assistance confidential. Are those requests and dollar amounts confidential now?
Yeah, these are pulled out of, some of these are existing examples from the statutes now. So this is sort of is pulled out as a example. So these are all taken or excerpts from existing exceptions. And that's how it reads now. You're looking at the middle one, right? During investigation.
No, I'm looking at the intro right under
Oh,
number 7.
the first
Yeah.
part. Yeah. I don't have my glasses on, but yes, it's an existing statute.
I think I understand what you're asking, Judy, and the answer is we are not proposing anything to be newly confidential. This is simply to make it clearer under the law as to, rather than creating the confusing situation that's resulted of saying something is confidential and not a public record. We're just saying it's confidential. That's the distinction.
Okay, so just to follow up, because the Sun Journal has received information about expert and investigative assistance and dollar amounts in cases that we've covered, what is the thinking of keeping taxpayer spending confidential? Why is this a confidential record? Was that discussed at all?
I don't think that's one of the exceptions that we talked about. That I think that was solely pulled out just to give us something to reference in looking at this problem. Colleen, maybe you can correct me if I'm wrong, but I don't think that was one of the exceptions that we were responsible for looking at as part of public records exceptions reviews. Now, that said, if that is one that you think we should look at the meeting on the 10th, I'd certainly be happy to do that.
Yeah, no, this isn't one of the exceptions that has been identified for review right in this cycle. It's taken from Title IV because I believe it relates to the Indigent Legal Services Commission. So that was, those exceptions were reviewed, I think, 2 years ago or last year as part of that cycle. But as I think Chris mentioned, if it's something you wanted us to, take a look at, I think it certainly would be, there is authority in the statute for the advisory committee to look at any exception at any time in terms of flexibility that way, outside of the specific timeline.
Judy, and then Jim had a hand up as well.
Just additional follow-up, and then I'll leave it alone. But if it was, the review was 2 years ago, there's been recent reporting on some of the processes at the Indigent Legal Services Office that have called finances into question. So I personally would like to see this come under review. That would be a request.
Your recommendation would for it to come under immediate review, not the next time that it is through the cycle.
Immediate review, given the recent revelations in that office about its finances.
Right, and the revelations regarding the finances of the Commission on Indigent Legal Services, as I recall, were primarily dealing with attorney fees, or are you saying that it was with
Fees
respect
and
to
services,
investigations?
overpayments, non-payments, just not kosher in general.
Okay.
Thank you.
Thank you. Jim,
There are two different standards here in number 4 and in number 6 about authorizing the release of information that could be tied to a particular individual's, in number 4, location, or in number 6, identity. And the permissible disclosure of information under number 6.3, the standards that used is as long as all information reasonably likely to reveal the patient or other person has been removed. In number 4, a more stringent and, to me, correct process is, in this case, it was location, but it could be for identity as well, could be determined. The reason I make this is the judgment these days of what is reasonably likely in terms of re-identification is something that, if we use the reasonable person theory, is no longer applicable. So I would just recommend that perhaps, if this is going to be a guidance, instead of saying all information reasonably likely, say all information that could be determined to reveal the patient would be a more useful, and I think in keeping with the intent, because re-identification technology now is something that I think most people are not familiar with, even reasonable people. And so using that reasonable standard amongst a group of people who are not aware of what that technology can do, I don't think would be the most helpful thing. By using this other standard of could be determined, it would be necessary then to find out if it could be determined. So that would be my suggestion, simply to include that standard of could be determined instead of reasonably likely in number 6.
and what are you, actually, let me ask a question based on that, if I could, Jim. In some ways, I feel we're comparing apples with oranges here. Number 6, which we deal with a lot in terms of review of legislation from other committees, has to do with the state's ability to collect aggregate information, sometimes on where cancer clusters are occurring, a whole
Right.
host of issues. And we want to make that information available so it can be used to help analyze and potentially resolve a problem. But we take out of that, or at least the goal is we're taking out of that information that could identify an individual. Are you suggesting that the language, and I think we use this, Colleen and Peggy, hundreds of times with various departments, that all of that language be changed to comport with the way it's defined, dealing with the confidentiality of victim records, which are individual records, not aggregate?
Understood.
Right, okay.
I understand the intent of releasing aggregate information. All I'm suggesting is that today, not a year and a half ago, but today, assuming that particular information isn't reasonably likely, is not a standard that I think is strict enough. And so perhaps that's something that needs to be looked into.
Okay.
Okay, so I was just sort of taking that other language and putting it over here. You know, in an age when for visa receipts is sufficient to re-identify 93% of the people without a name and address on any of them. It's a different world than it was 2 years ago, 4 years ago. That's all.
Okay. Senator Carney.
So just to clarify, Jim, are you asking that that statutory provision, like the one related to the indigent legal services, be promoted to review at this time?
Well, I don't, with only one more meeting, maybe that's not going to be workable, but I do think in looking at these two different situations, that the stronger one would be the one that I would suggest be used in general. That's all. And so, and it looks like, I mean, it certainly could look like, well, that's not really different. It is really different.
Yeah, I agree with you that it's different. It seems to me, and Colleen, maybe I'm off base here, but would we have to review the underlying statute in order to revise the draft language here?
No, and this was the recommendation of the subcommittee, I think, is really that these examples be used as drafting guidance, and sort of it's to develop drafting guidance for standardized language. And so I think we could certainly incorporate the concept that Jim is articulating about and raise the issue for drafters moving forward to consider that the language that's used now, you know, reasonably likely to reveal someone's identity might not be strong enough, and they should consider it could be determined language that you described. So I think we could work that into the recommendation and to the guidance that we would develop on your recommendation for the revisor's office and other drafters in our office to use. That makes sense.
Thank you, Senator Carney.
Yeah, can you just, Colleen, point me to the statute underlying paragraph 3 under point 6?
Let's see.
It's on page 7 of the pink document.
Prescription monitoring.
Yeah. I
Yeah.
think I have to go back and look at the
You
other
don't, yeah,
report.
and
but
it's okay to give it to me at a different
I
time.
can give you this, yeah, I'm just off the top of my head, I'm thinking it is in Title 22, but we'll have to go back and look.
Okay,
We
thank you.
just pulled it out as example, so we didn't pull out the statutory references.
Yeah, thanks.
Oh, actually, maybe it's in the report itself.
Yes, Jim.
I'll get back to you in 1 second.
Yeah, I was looking at this as future guidance, not as going back and changing anything else. So, which I think is what the spirit of this is.
So and correct me if I'm wrong, you are suggesting that in terms of the guidance that we give to the revisor and to all committees looking at legislation like this, is to put in language closer to could be determined are confidential instead of this reasonably likely to reveal standard. So it's a moving forward drafting suggestion.
Yes, correct.
Is that right? Okay. So
Yeah.
different than what Judy is talking about, reviewing a particular statute's confidentiality.
Correct.
And just to Senator Carney's question, it's Title 22, Section 7250 is where the prescription monitoring subsection 3 is exception is
Thank you.
located. You're welcome.
So then, Colleen, if the committee wants to take this approach suggested by Mr. Campbell, how do we do that in this document? Because you can't change the language that's in Title 22.
Yeah, so I think that we could include it. I mean, this is really I think we haven't really figured out how we're going to turn this into specific drafting guidance, but at the top of the document, there is a general suggestion that I think the subcommittee agreed to that, when drafting public records exceptions, you want to be consistent in your language and you want to designate a record as confidential. And so we could include an additional recommendation, describe what Mr. Campbell said as suggested language, and then provide some specific examples and maybe talk about the differences that he highlighted in number 4 and number 6, and talk about that and sort of provide some more, sort of revise this guidance document that then would be shared with the revisor's office for potential incorporation into their drafting manual. That was the idea that we were thinking would be sort of the next step if you endorsed this, these suggestions for clarity of language, and then that would be then used by drafters moving forward, and then we'd also have the advantage or the ability to share it with the advisory committee and the public records exception subcommittee as they look at future proposed exceptions and existing exceptions as you move forward.
So would this come back to us then in an amended format to what we're looking at right now?
If you'd like to, it certainly could. We could have that for our we could work on something and bring it back to you for your next meeting if you want to sort of hold off on accepting this recommendation until then.
Okay. And is that something that would be amenable to the subcommittee, Chris?
Absolutely.
Okay. Does that address your concern, Jim?
Yeah, yes.
But we still have the issue of the review. What steps do we need to take if the committee wants to support Judy Meyer's view on?
I think my suggestion would be to have a sort of a vote or consensus of the full committee on that. And then you could recommend that the subcommittee take a look at it. The subcommittee, I believe, does have one more meeting scheduled on
December
December
10th.
10th. And that may be something that they could, I don't want to speak for the chair, but it could be added to the agenda if it's the recommendation of the full committee, but some vote or agreement would be good probably.
Then there are 2 hands up. And who are they? Oh, okay. The yellow hands. I'll first call on Eric and then Kevin. Eric Stout.
Yeah, I just wanted to add my support to Jim Campbell's suggestion that if
I'm
there's
sorry,
an option-
I couldn't hear you.
I just wanted to add my support to Jim Campbell's suggestion that in the language guidance, drafting guidance, if there's an option to choose the stronger of the protections for privacy to do so. And just as the IT member on the committee to, emphasize what Jim is saying, that there's increasingly ability to take bits of data elements and combine them and cross match them, and then identify somebody personally with just bits of data. And that's, a fear for, data breaches and hacking and all that kind of thing. So I agree with what Jim has brought forward to, if there's an option to choose the stronger of language to do so.
Thank you. Kevin?
Yeah, just a follow up on the public exceptions piece. I just note that typically when we review as a part of the committee, we have the benefit of input from the agency that applies the provisions and stakeholders. So I'm not sure, it might be something better suited to table for next year's review, depending on whether we're able to get feedback from the relevant agency regarding that provision. I just note that we were planning to meet in 9 days, and that may or may not be enough time to get that feedback that we utilize to be able to warrant such a review.
Thank you. Eric?
I did want to acknowledge what what was Kevin just said, but yet if this is a hot issue in the press and public awareness, I think we should attempt to try to, get some input on that. And if we can deal with it at the next subcommittee meeting to do so, but it might not be practical if we don't get the feedback, but I think we should try.
Thank you. Judy, would you like, we have two things to deal with. Jim's recommendation, which I think the subcommittee has said they will review at their next meeting, doesn't take formal action by us. Judy's request is to take an item out of order in terms of confidentiality review. That would require a motion, I believe.
I think so.
Okay. And I don't know if you can frame the motion to accommodate the concerns about challenges that doing this within 9 days would present, or if you want to do that, it would be your motion.
Okay, so I would make a motion that the subcommittee take up this narrow piece of that statute, Colleen, whatever number it might be, to look at the confidentiality of financials in the Office of Indigent Legal Services, given the recent public understanding that the financial dealings in that office have been in disarray. This is taxpayer money, and I think that that warrants a more immediate look than 8 years from now, because if it was reviewed 2 years ago, it'll be 8 more years before it comes due. And I think it should be expedited, whether that's next week or in the new session, sooner than 8 years from now.
Okay.
That's very wordy, but that's
Yep.
the gist.
No, I understand. And it's Title IV, Section 1806, subsection 2. So that's where it's located.
Can I make a friendly suggestion that perhaps the term disarray come out of the motion and that there have been questions raised
Of
or
course,
issues raised?
questions raised, yes.
Thank you. We have a motion. Do I have a second?
Second.
Senator Carney? Oh,
There's a lot of.
okay. The press has their hands up. I see a second from Amy Beveridge. And Vicky, did you have a question, or I want to get the motion out and then we can take questions?
Yes, thank you. It's a question.
Okay, so we have a motion by Judy Meyer, which you have, and a second by Amy Beveridge. Is there any discussion, comment? Vicky?
My question is, and I understand the seriousness of the concern in terms of the confidentiality that was discussed in the press, but do we normally make law based on a situation like that? Do you understand what I'm asking, or should we be more broad brushed about that?
As I'm hearing it, it's an issue being raised about a specific statute and not a broad brush view of confidentiality in general. Does that reflect your concern, Judy? And I don't know if that fully answers your question. But what the request is to
That there was a
review-
loophole in the statute, you mean?
No, the request is to review that confidentiality provision in that particular statute, which had been reviewed 2 years ago and would not be reviewed for another 8 years. So it's taking it out of order and moving it up due to a specific concern about that statute.
Okay, but it also is tied to an incident, right?
It's tied to a particular program, I would say, rather than a single incident.
Okay, but you see my point.
I do.
Okay, then I'll be quiet. I just wanted to raise it. Thank you.
Christopher.
Thank you. I just have two questions. One is for staff. Would we still have the material that was submitted when that review occurred, whenever it was 1 or 2 years ago, that the subcommittee could obtain to review to get I think Kevin's point is important as far as, agency feedback. But if at least we have that information, that would be helpful. And I'm hopeful that that 9 days would be enough notice to perhaps have someone from the agency attend or participate. But in any case, that's my first question, when we have those materials.
We can, I don't recall off the top of my head if we actually received a questionnaire
Okay.
related to that previously, but we certainly have the materials and can go back and look and see if we have it, and we'll be able to share it with the subcommittee. And then we also will definitely, if the advisory committee moves forward, would definitely reach out and ask them to complete a new questionnaire, or as you mentioned, be present at our subcommittee meeting to answer questions and provide information.
Okay, great. That'd be extremely helpful, I think. The other question I have is for Judy. Specifically, Judy, would you or someone who has an appreciation of your perspective on this matter be able to attend that meeting? Just to make sure that, I want to make sure, I'm not quite sure I understand the concern about it. It sounds like it's an important one, and we should definitely be looking at it. But I would just hope to have your perspective or someone's perspective who shares your perspective there.
I'm happy to do that. I'm happy to pre-share the main monitor's reporting on this that lays out what the issues were in that office.
Yeah, I've read that article, and it would be helpful just if someone were there to be able to speak a little bit to this exception. So those are the questions I had. Thank you.
Thank you. And just in response to your first question, Chris, I think the motion contemplates that time might be an issue, and that there is an out if it cannot be properly considered within 9 days, but that it be moved up to the front of the line at a subsequent date. Is that accurate? Okay. Are there other questions or comments from committee members on the motion before us? Ms. Finn.
Yeah, just a quick clarifying question, and it may have been in the motion and I may have missed it. It's my understanding we're looking at Title IV, Section 1806, subsection 2. And I believe, and under subsection 2, there are 6 subparts, and I believe that discussion was specifically about Part E.
Yes.
Is that the only subpart that we are in that section?
Hey, that's the only one that was included in the example. I haven't pulled up the whole thing either, so I don't know if there are other categories. If I think it would be within
it's
the
magically going to appear.
Yeah, I was just gonna say, I think it would be within the subcommittee's discretion to look at the whole subsection if they wanted to. But I'm not sure what, I think the motion was specific to paragraph E, unless it's amended.
It is specific to paragraph E because of the expenditure, the public expenditure.
That E is focused on a request that either the attorney or the indigent client himself or herself makes for expert or investigative assistance. So this isn't a huge account. It's specific requests for additional non-attorney expenditures. So as long as you're aware, this isn't looking at everything that an attorney has submitted, because that is public information. And to tell you the truth, I'm not sure if this remains confidential. I know this says that it's confidential, that the director's decision whether to grant or deny the request is confidential until the case is closed. And I remember the discussion being that if you make that information public during the course of the case, that reveals the strategy that a defense attorney would be using, and that would provide more information than is fair in a criminal prosecution to the prosecution itself. So I agree that it looks like it's confidential forever. I'm not sure if that's true.
So your concern, or I think the issue you're raising is, would a change, and this could be something considered by the subcommittee, interfere with the attorney-client privilege in terms of strategy about litigation?
Yes, and
If it's disclosed during the course of the proceeding.
right, and knowing that an expert on a certain kind of scientific investigation has been requested by the defense tips the hand of what their strategy is going to be in a case, which is not required in any other situation. But I understand the concern that that would be confidential forever. And I'm not sure that that language clarifies that that information is public at the end of the case. It just looks like the decision about whether or not it's paid or it's approved is public at the end of the case. So we can certainly look at that, and just interesting what we use for examples and the issues it brings up.
You should have picked another example.
Yeah.
Judy.
Just to explain better my concern, here's a real life example. We covered a trial probably 5 years ago of an elevated aggravated assault. The defendant hired 4 different attorneys over a span of 2 years, and each attorney hired investigator and hired expert witnesses. So the cost of the trial was quadrupled for this particular defendant. And it was determined that the defendant was purposely moving this along to delay his trial. The bills that we did see did not say hired an expert in such and such a thing. The line item is not that. It's just expert services or investigative services and a dollar amount. So it's really the expenditure that I have a concern about, not the services.
But that information was not confidential because the proceeding was over.
We received that information at the last of the 4 attorneys during trial and reported that information. And I can dig that up as well to give to the subcommittees to help.
Okay. We have a motion and a second. Do we have any additional discussion? And I'm looking. Can you get back to the regular screen so I can see yellow hands because they don't show on. I am not seeing hands up in the room. I am not seeing hands up in the virtual world. So I believe it is time for the roll call.
Sure. So we are, the motion is to move review of Title 4, Section 1806, subsection 2, paragraph E, to the Public Records Exceptions Subcommittee for review either now or in the future. Senator Carney.
Yes.
Representative Harnett.
Yes.
Linda Cohen.
Yes.
Eric Stout.
Yes.
Justin Chanette.
Yes.
Amy Beveridge.
Yes.
Linda Clancy.
Yes.
Chris Parr.
Yes.
Taylor Asen is absent. Jim Campbell.
Yes.
Suzanne Goucher.
Yes.
Judy Meyer.
Yes.
Julie Finn.
Yes.
Jonathan Bolton is absent. Kevin Martin.
Yes.
Vicky Wallach.
Yes.
So that is unanimous of the 14 members present. Thank you.
Thank you. And with respect to Mr. Campbell's issue, that's already been discussed, resolved, and will be reconsidered. Is there anything else we need to do with respect to this subcommittee's report? Senator Carney?
Yeah, I agree, Jim, with your concern about the language in the example under number 6. And I'm just wanted to know, Colleen, if you could let us know whether Title 22 is included within the next batch of statutes to be reviewed.
It will be. It's in the next, we're finishing up with Title 21A this year, this cycle. And so in 2022, the advisory committee will begin the review of the next sequence of titles,
Yep.
including Title 22.
Great, thank you.
Thank you. Is there anything else, Chris, from your subcommittee?
There is, and I'll be very quick about it. I would invite my other fellow subcommittee members to make any comments they want to make in general, and to do that, say that earlier. But the last item that we discussed was with respect to broad categories of exceptions. The advisory committee is charged with exploring whether it makes sense to identify broad types of information that the statutes uniformly designate as confidential. The two categories most often mentioned, or at least most often mentioned by our group, were proprietary information and some description of personally identifying information. The subcommittee reviewed and discussed examples from current law that provide public records exceptions for quote, proprietary information in various terms related to personal information, quote unquote, and considered whether it makes sense to recommend a broad exception of these terms within the definition of public record in the Freedom of Access Act law itself. After discussion, and there was a lot of work put into this by Rachel that we ended up not being able to turn to because, which I felt really sorry about, so I apologize again. But after the discussion, the subcommittee agreed that a case-by-case approach makes sense for proprietary information. Having the legislature consider the context of each industry or business when establishing an exception for proprietary information makes sense. The subcommittee therefore did not propose any action with respect to proprietary information, and I would even say in general. Eric Stout shared his experiences working with the Federal Privacy Act. He suggested a general category of information be included from public records, tracking the language used in the personal contact of public employees exception. That's in the section 402 of Title I. Basically, if it's personal, it's not public, is sort of the general principle. Mr. Stout proposed a definition of personally identifiable information in a proposed amendment to add a new paragraph V as an exception to the definition of public record in Title I. Some subcommittee members expressed reservations about making general exceptions for personally identifiable information when there may be circumstances that require the disclosure of that information. For example, names of persons who are arrested. The subcommittee therefore decided to take no further action on that point. And that is my report for that section. And all I have after that is unfinished work, but I won't move on to that obviously until we are ready to.
Thank you. And thank you for the work of the subcommittee. You've done quite a bit of work in the last month or so. Thank you. Is there anything else that we need to do with the Public Records Subcommittee? Then I would like to go back to I see that Brenda Kelty has joined us. I would like to, do I need to take the motion to take an item off the table? No, we can just go back to it. Thank you. Going back to the proposed drafts of letters regarding, I'm sorry, that's my wrong agenda. The review and approval of letters to the public access ombudsman and Maine Municipal Association requesting data requests on matters that it is taking 2 hours or less to complete. And I need to pull those my morass here. Brenda, there was a question posed by Eric that I will have him repeat, and then there were also some suggested changes to the letters regarding the dates. So welcome to the meeting, Brenda. I'm
Thank
going
you.
to ask Eric to repeat his question regarding your interaction with agencies, and then I will explain the changes being considered regarding the dates in the letters.
Okay.
Yes, so the letter is drafted to say that the new record keeping would start December 1st, which is today. And I had only suggested that we defer to you, Brenda, about your reporting requirement request to the agencies, that it might be cleaner to start that January 1st. It also gives them a month's notice instead of jumping them this afternoon. But would defer to you about whether January 1st is a cleaner start date for that.
Yes, thank you, Eric. I do a calendar year data collection, so it really isn't fair to ask them for 2021 data at this point. So I was preparing my email to go to the public access officers, and my intent is to ask them starting January 1st, 2022, and we'll get the 2022 calendar year.
Well, just to does that respond to your question, Eric?
Yeah, I think that would be in alignment. That's what I was assuming that Brenda would probably say.
And thank you. An additional question that arose, Brenda, was the letter currently calls for a report back to the full committee by December 1st, 2022. There was a concern that that's pretty late given when our work wraps up. And that would perhaps be only 2 weeks before the work wrapped up in the next session. So there was a recommendation. The first recommendation now is to have the reporting requirement begin January 1st, to have all information that agencies have gathered be through September 30th, 2022, with it being provided to this committee by November 1st, 2022. Do you have views or concerns about those new dates?
Well, it's a little bit different from what I usually do because I don't ask agencies for quarterly reports, for instance. I just get an annual report from them, and usually not until the following January. So I don't expect to collect, for instance, my 2021 data from the agencies until January 2022 at the very last 11th hour. And then I incorporate it into my report just because they're still collecting information, right through the end of the calendar year. So I can certainly ask them. This is more like a quarterly report, and I understand the time frame and the reason for it, and ask for their patience and cooperation in providing this. I do think that there's a real value to this data, and I want to see it too. I'm very interested in it. So I will certainly ask them to do the best that they can to give it to me on a more, it's like a quarterly report on September 30th. So I'm fine with that.
Then do we need a motion to amend the letter for approval? We have, so we can vote on it as amended. So the two letters would require the information be collected beginning January 1st, 2022 through, just for this purpose, for the purpose of this letter, through September 30th, 2022, and provided to the Right to Know Advisory Committee by November 1st, 2022. So do I have a motion to that effect? And then that would be to approve the letter as amended.
Yep, so moved.
Motion made by Jim Campbell. Do I have a second? Senator Carney, any discussion? Looking around this room, look at yellow hands, Mr. Parr.
Thank you. I'll try to be brief. I appreciate the fact that we're going to start tracking as of the first of the year, because we were going to, at TPS anyway, need to set up a way to a coding, I think, is what we're going to end up doing to track the information accurately. And that should give us more than enough time at this point, a month's time. The concern I have, I'm going to support the letters. There's no question about that. Unless, I guess the only caveat would be, I assume that the Maine Municipal Association is okay with collecting this information, and that Linda, as municipal representative on the committee, is okay with it. But the concern I have is similar to the concern I have about tracking the data generally with respect to FOA requests. And I think there is value in tracking the requests. What tracking the requests generally that we do each year doesn't capture is the qualitative aspect of each request. An agency could conceivably have, we've had one request. We had one request that one person ended up spending more than a month's worth of hourly time on, just on that request. And so if we reported that on its face, it looked like if that was our only request, so that's just one request, but when you look at the amount of effort that was needed to work on that request, which is now being litigated, you might see that quantitative figure in a different way. The concern I have about with respect to collecting this data point is that it doesn't distinguish between what we've been talking about for a while now, commercial requests, and requests that are being made in the spirit of the right to know law. Just to give an example, I've already spent numerous hours, including an hour and 20 minutes yesterday speaking with another attorney about one request that we've received from I think from TransUnion, which I think is like a data or a credit reporting agency of some kind. I'm not completely sure on that, but they're requesting bulk data, and we've spent a considerable amount of time, as well as in addition to the time that I spent on the phone yesterday. And part of the reason why is that there's PII included in this information, and there are various legal considerations that we have to sort through. I won't try to guess how many hours we've dedicated so far, but my concern is that we are going to end up, I guess it would count toward this year, so we wouldn't end up reporting on this request. But if we got a similar request next year, if this request were made next year, we would absolutely report more than 2 hours were spent on this, whatever it ends up being. But what isn't captured is the reason why it's being asked for, which I don't have. There's nothing in our statute that allows us to ask why it's being asked for. I can only try to infer. And maybe an argument can be made that any request is in the public interest. So it's the fact that there isn't that distinction yet that is troubling to me. All that said, I think that the waiver issue, as well as the commercial request versus in the spirit of FOA request, I think these are important enough that I'd be willing to work in the off season, as it were, in looking at these two things, and looking at both the waiver, how waivers might work, and how we might treat commercial requests. I've looked at the Illinois law, which is, I think, impressive. It's extremely sophisticated, and it addresses both of these types of things in a way that I think is reasonable and balanced. But so I will be supporting both of these letters. But it's that same concern that it doesn't quite tell the full story necessarily at the end of the day. So that is what I have to say.
Thank you very much, Chris. I think that I understand your concern. This is the first step in the process to try to figure out how the new statute is working. If we find that the data that we receive doesn't answer all of the questions that we have, then we might have to revisit our approach to it. But I understand the concern. Are there other questions on the pending motion or comments? Seeing none, I would call the roll, please.
Are we taking each letter separately? So this is just the first letter, or is this motion apply to both
I think
letters?
the motion applies to both
To
letters.
both letters. Okay, good. Just thank you. I just wanted to clarify that for my notes.
I'd like to take a vote on every paragraph.
Yeah. Thank you. Okay, so the motion is to accept the letters with the amendments described related to the reporting date back and the scope of the timeframe for when the information will be collected. Senator Carney,
Yes.
Representative Harnett,
Yes.
Linda Cohen,
Yes.
Eric Stout,
Yes.
Justin Chanette,
Yes.
Amy Beveridge,
Yes.
Linda Clancy,
Yes.
Chris Parr,
Yes.
Taylor Asen is absent, Jim Campbell,
Yes.
Suzanne Goucher,
Yes.
Judy Meyer,
Yes.
Julie Finn,
Yes.
Jonathan Bolton is absent, Kevin Martin,
Yes.
Vicky Wallach.
Yes.
So that's unanimous of the 14 members present. Thank you.
Thank you very much. Thank you, Brenda, for helping us out on this one. Going back to the regular agenda, reports of subcommittees. The next report is of the Remote Participation Subcommittee. I will be delivering that report as the subcommittee's chair. We have no action items today, but I do want to bring the full committee up to date on the issues that we are looking at. We had our first subcommittee meeting on November 10th of 2021 after our last full meeting. That was pretty much a planning meeting, and we had a fuller subcommittee meeting this morning. And I'm not going to use all those fancy adjectives that Chris used about the discussion and how much fun we had. But it was a very good meeting, and we do have a couple of issues on the table that I just want to make the full committee aware of. The first thing that we looked at was a possible piece of legislation worked on with Brenda Kelty and Peggy regarding allowing municipalities to adopt a remote policy, a remote participation policy remotely if necessary due to an urgent situation or an emergency. We are tinkering with that language. The subcommittee was supportive of the effort, but we need to finalize some language, and we will have that before the committee, the full committee, on December 15th. I also alerted the subcommittee to LD 1772, an act to amend the remote meeting law in Maine's Freedom of Access Act. This was a bill that I submitted on behalf of Maine Municipal. It has been approved by Legislative Council, and that bill will go through the regular legislative process. There's no action needed by the Right to Know Advisory Committee. The bill will do two things. It will provide more flexibility for individual municipalities and their various political bodies to define what an emergency is, such that it requires remote participation. The other thing that it does is it will allow a municipality to adopt a sort of omnibus remote participation policy that would be applicable to all entities within that municipalities, planning boards, appeals boards, et cetera. Just a cleaner and easier system rather than to have every subcommittee, every group reinvent the wheel. So that's LD 1772. And then the longest topic that we discussed was, and I raised this at our last full committee meeting, the issue of remote participation by residents of correctional facilities. And I won't go into full detail because we'll report on this more on December 15th, but you might recall that we had an issue in the Judiciary Committee, a bill dealing with parole, the reestablishment of parole in the state of Maine. There was a great deal of interest amongst persons that are currently residing in state prisons to participate in that legislative process by providing oral testimony. That did not occur for reasons stated by the Department of Corrections, that it was not something that was possible for them to do. I had concerns, as did other members of the Judiciary Committee, and a similar issue arose in criminal justice and public safety on a matter that affected the day-to-day lives of persons who are incarcerated. And they were concerned about their lack of ability to participate in the legislative process, as do all other residents of the state of Maine. We did I didn't do anything actually, staff did a survey of other states to see if this is an issue that's being addressed elsewhere. And we have not been able to find a model in other states. Today, we also reached out to groups that advocate for victims of crime, survivors of crimes. They submitted written testimony to organizations raising concerns about the impact that participation by persons who have been convicted of crimes might have on those who were the victims of those crimes. Very heartfelt and very powerful testimony. We today also heard from the ACLU of Maine advocating for increased participation by persons who are incarcerated, but recognizing that there would need to be steps taken to make sure that people are not being re-traumatized by the method of that participation. My goal was simply to allow people who are incarcerated to present oral testimony, as all other citizens of Maine are allowed to do. The ACLU of Maine pointed out that Maine allows incarcerated persons to vote. We have a fairly low incarceration rate, and they want to do everything that they can to make sure that the First Amendment rights of persons who are incarcerated are protected and valued. But they also recognize the need to work with the advocates for survivors. So we are going to put out a request, again, not me, staff is going to put out a request to the Department of Corrections to see what issues this type of proposal would raise for them from a security and personnel point of view, and also to bring together as many stakeholders as possible from both civil liberties groups and also entities representing victims of crimes and survivors, to see if we can find a way to balance all of those various concerns. So a lot of very good discussion today, but not a lot of resolution. We have time to work on this before our next meeting. We'll be meeting as a subcommittee on the 15th prior to our full meeting. And we also recognize that this might be an issue that will not be able to be resolved in the time that we have, at least in terms of recommendation of a statute, but we want to keep moving the ball forward. I have other members of the subcommittee here today. If there's anything I forgot or misstated or something they would like to weigh in on, please take the opportunity to do that now. And I will look around. I see Amy Beveridge with a real hand in the air.
The one thing I just want to put out for consideration in the future, you know, we have in this subcommittee, we've focused mostly on emergency meetings and emergency needs for a remote meeting. And we really do need to consider to put it as it was stated before, you know, we can say emergency right now because we are still in a pandemic, even if it's not a formal state of emergency, but eventually someday, hopefully we'll get out of this. And we should really consider having a standard for at least the public to be able to attend meetings remotely, you know, on an ongoing basis. I thought that the representative from the ACLU actually articulated that quite well. So I do, while I don't think it's going to be something that we'll be able to tackle as a committee, you know, in the next several weeks, it is something we really need to be considering. We've been talking about remote participation at meetings for years before the pandemic happened, and the pandemic accelerated that tremendously and also proved that it is possible and it can be done. We really need to be thinking beyond the pandemic too for this too.
Thank you. And that's a great point, Amy. Is one of the silver linings of the pandemic, and we always need to look for silver linings, was that we have found that remote participation can work, can bring more members of the public into the municipal government process and the state legislative process. And we need to look at what parts of that we can retain to make sure that that continues, that we reap the benefits of the ability to participate in that way. Thank you for raising that. Eric.
Yeah, I just wanted to double down on the point that Amy and also Tom just made, that throughout the world of business and government and, you know, public policy, this has become the new normal to be able to take advantage of the technology. And we do know that the policy that we have is based on what we understand to be the majority will of the legislature, that public meetings be held in person. But you know, the times they are changing, and this is the new normal for having productive meetings in business. And also many people have commented that they're actually seeing the local governments are seeing an increase in participation because people don't have to go down to the town hall or something. They can just Zoom in, and it's convenient, and it actually is increasing the participation and the democratic process because of the technology.
Thank you. Other members of the subcommittee? Seeing none, again, I want to thank all of my colleagues on the subcommittee for their hard work today and for their hard work as we move forward. We have two other items on the agenda. The first is for committee members, and that is, are there any other issues?
I think you forgot.
Yes, I did. Because Judy had 20 minutes allotted to her for the entire meeting and has used that up. Judy, if you could report on the technology subcommittee using all of the adjectives and adverbs to describe the wonderful work. Sorry about that.
No, that's perfectly all right. Our task was to consider how best to handle list management tools and consider the accessibility of these off-system records management systems like MailChimp and other third-party platforms, and also to look at existing policies regarding capture and retention of email, text messages, and other tools that are less discoverable, and to bring forward recommendations. So we met twice. During our initial meeting, Eric, Brenda, and Kate McBrien, who by the way is my new hero because she's already doing much of this work for us, walked us through state policies and guidance for digital records management and the archives retention schedules, and gave us kind of an overview of how that landscape works. And then during our second meeting on Monday, we reviewed retention policies provided by Maine School Management, MMA, the Maine County Commissioners Association. And of these, Maine School Management has a really impressive, fully developed records management policy that directs school superintendents to develop records management programs by district. And what I thought was interesting about the policy is that it explained why. And that is that these policies need to pay attention to the proper retention and disposal of the school unit's records, not only for compliance with laws and regulations, but to protect the legal interests of the school, the staff, students, and to ensure that the school unit is managed effectively. So it wasn't just do it. It was, this is why you need to do it. Maine School Management also reminds superintendents to do this, reminds them about the records retention schedules, and routinely highlights revisions to these schedules. MMA and the Maine County Commissioners do not have written retention policies for their members, but they do share information about retention policy development and ensure that their members are aware of the archives retention schedules. So if they get a question about records retention, those agencies or associations push their members to the archives. Brenda also briefed us on the records management training for lawmakers, which is included as part of the 1-hour FOA training at the beginning of each session. And she did explain that her regular instruction to state agencies is that it is their responsibility to manage records and that they need to own the practice. And that is hard because we're relying on humans to manage these records. Kate talked to us a little bit about the Archives Records Management Training Division, noting that they receive regular questions about records retention from all levels of government, and that the division offers training, but not everybody takes them up on that, which is unfortunate. So the archives are currently updating the state's general schedules on all things e-communication, including third-party platforms, text, and other communication platforms. And once those schedules are complete, they will be adapted for counties and municipalities. So based on these wide-ranging conversations over 2 meetings, it seems the policies are in place, the retention schedules exist, and they evolve. But what may be lacking is awareness of this information and a lack of awareness of available training options. So we have 2 recommendations. Encourage MMA and Maine County Commissioners to follow Maine School Management's example and send out annual reminders about retention schedules and available training. And the Maine State Archives has agreed to work on language for guidance on that. We're not including Maine School Management in that recommendation because they're already doing it. The Maine State Archives would also consider including federal policy language in that language that would encourage government officials to be mindful of personal email and other personal messaging applications and instruct them how to transfer texts and other messages onto government servers. The second recommendation was to have Brenda and Kate, who were both on board with this recommendation, to do additional training at the legislative committee level specific to records management, including social media platforms, during each committee's orientation sessions, which would augment the general FOA training. So it would be legislators would get their hour of FOA training, which is kind of an overview of the landscape, and then each committee would get more precise orientation on records management and retention. And I think Eric said this at both meetings, but FOA depends on good records management discipline. And our feeling was that these 2 recommendations would raise awareness of what is in need in a more regular and concrete way, annually anyway. And it may be enough without writing anything further into statute. The other piece we were asked to look at was these third-party platforms and how to capture those communications. And once again, the archives is ahead of us. They are working on a pilot program to manage social media communications and capture those accounts for elected officials, which would include MailChimp and other platforms. Kate expects to address that concern with this pilot program, work out the kinks. It's not a quick fix, but it's something already in the work at the archives. So we're going to look to the archives for those solutions rather than trying to reinvent the wheel on this. So we have two recommendations. We have planned no future meetings. And I apologize, I didn't bring this in writing because I'm just relying on my notes, but I am more than happy to have other members of our very engaged committee, I have to say, weigh in if I've missed anything.
Thank you, Judy. And I would open it up to other members of the subcommittee if they want to weigh in on or amplify anything that Judy has said. Chris Parr.
I'm more just amplifying. First, Judy did a wonderful job just now in chairing the committee, but I do want to amplify. It's just so fantastic to see what Kate is doing over at State Archives, and I think we need to be all appreciative of that work. So,
Thank you. And thank you very much to Kate and Brenda for all of their work and volunteering to get the legislature in compliance with the laws that it enacts. Appreciate that. Do we need to, will you put the recommendations forward in something written for the meeting on the 15th so we can?
I'm happy to do that. Yep.
Take a vote. Great. Are there any questions from committee members for Judy regarding their work? Seeing none, thank you very much. But you're not allowed to say anything else now for the rest of the afternoon. And we control the mics from over here. The next item, unless I'm forgetting something else, which is certainly possible, is before I turn it over for public comment, is are there any other issues that members of the committee want to raise today regarding all things freedom of access, right to know? And I am not seeing hands, and I know that there are some committee members who need to leave due to other obligations. But it's okay. So thank you all for being here. And the next formal item on the agenda is I've received a couple of requests, or maybe multiple requests, regarding allowing public input into these meetings. And you know, we are the Right to Know Advisory Committee. We are about government transparency. And I think that that provision of a public comment period is something that we should do, and I hope to be able to continue to do in the future. So I would now open it up. If there are any members of the public who would just like to provide comment to the full committee, I would let you know we probably will not be able to answer specific questions, but are certainly interested in hearing issues that you think need to be addressed or that you have concern about, so that we're aware of those. And I do see one hand up, and that is Mr. Ken Capron. I hope I'm saying your name correctly. I know we've, I bet I got Ken right, but perhaps not the last name, but I know that we've traded some emails, and I welcome you to the committee, sir.
Well, thank you very much, Representative Hartnett. And I appreciate the opportunity to speak. I first started coming to the Right to Know Committee in 2008, I think it was.
Could you just state your name for the record, sir? I'm sorry.
Oh, Ken Capron from Portland, Maine.
Thank you.
Yeah, it's like an apron with a C on the front. And it's Ken with like an N with a K on the front. Anyway, so I think it's fantastic that you finally have gotten around to considering taking some public comment at these meetings. I may be one of the few public people who, individuals who actually has pursued FOA requests on a fairly aggressive basis, and I have a good deal of experience at and maybe not not left a good taste in my mouth, but I'd love to mention a few things. In particular, I think it might be helpful, and maybe you already have a method of doing this, but it might be helpful to listen to, not make judgment on, but to listen to individual cases to see what different departments are doing. I've had varying results depending on the department I talk to, and my first reaction is if I get rejected or if I'm given some outrageous dollar amount for records, my first reaction is to contact Brenda, and she's been fairly responsive, although we don't always agree on access. But I think it would be important to review some individual cases. Some of the things that I find are problematic for a member of the public, especially to go after a FOA request, is when I hate to say this, I'm an elderly person on a fixed income, but when somebody throws a $1,300 tag on a freedom of information request where you ask for review the documents, not copies, but review documents, some departments will say, well, we need our $1,300 up front. And then if you review them and you make copies, then we'll adjust accordingly. I suspect for many Mainers, $1,300 is too much. I also suspect that there are cases that are current, where it might be wise for a FOA committee of some sort to intervene. And I refer specifically to the CDC issuing or not issuing records related to the number of cases and specifics about the cases. And I know one organization that was on the initial request quoted $600 to get some of the information, and when they asked for a little bit more information, it came back as $6,000. So even for agencies that are professional information requesters, it can get quite expensive. I can't imagine what newspaper people pay for information. I also am concerned a little bit about double dipping, in that if I go and I ask for information that's already been requested by somebody else and provided by somebody else, and they're going to charge me $25 when they've already gotten $25 from somebody else for the same request, that's not quite how we like to see government run, I don't think. And so I'm not sure how you would ever address that, but I think there's a methodology that some departments have come up with that allows them to make money off the records requests. I also would like to seriously suggest or ask if there couldn't be some way that we would publicly post information that has been requested in order to specifically prevent the possibility of a double dipping. But there again, I mean, if I ask for a grant report, for example, or grant information, there's no reason that can't be posted publicly for all to see. If we had a website where we could post mostly a PDF file or something like that, that would provide other people with access to the same information. In most of the cases where I have requested information, there are usually other people wanting the same information. And then there's this issue of statute of limitations, and I'm involved in one situation right now where a piece of information what came from 2014 that I had requested under FOA and been denied. Now it's 7 years later, and certainly it's beyond the statute of limitations, but I only became aware of it within the time frame, when I first filed my request. And so the statute of limitations that shouldn't run from the time the document was created. It should run from the time that the requester became aware that the document existed. And the particular document I'm talking about was some grant information, which may or may not have involved fraud. But if I had received that upon the initial FOA request, it would have had a much different outcome on a current case. So I won't go into that much further than to say that the statute of limitations needs to be looked at pretty seriously. So I think that those are my major concerns right now. I do think leaving discretion up to a department head or a commissioner it's certainly one of the things that the federal FOIA legislation deals with is this idea of discretion, and they try very hard in the federal law to negate any discretion for the simple reason that there's too much politics involved. And so I'm really concerned about giving people discretion on whether to have a waiver policy or not. And I could bore you with more, but that's all the fun I can stand this afternoon. So if you have questions, I'll be glad to answer them, but the opportunity to comment is greatly appreciated.
Thank you, Mr. Capron. We appreciate your being here today, and I know that you follow us pretty regularly, and we appreciate that as well. I would just point out we are looking into the waiver issue. It's one of the reasons we're collecting the data on the amount of time that it takes to respond to requests and exploring whether or not if there is a denial of a waiver, if a reason needs to be provided. So I appreciate the input. Are there any questions from committee members for Mr. Capron? I am looking around and I'm not seeing any electronic hands or any hands. If I'm missing anything, Mr. Stout, Eric.
Yeah, hi, Ken. So my role in FOA support is to try to provide technology support to agencies who ask it. And I've been keep track, and I've been involved in exactly 100 FOA requests so far this year. And every year it increases the technology support requests. Sometimes that can really help to reduce the cost. Other times not. It depends whether the records being requested are paper-based or easily searchable. And sometimes broad requests, everything about a certain topic from anybody in the department, that really drives up the cost. So trying to identify like key people within an agency, like the director or, 5 or 6 people that would be, program leads, can really reduce the agency's cost estimate rather than requests like anybody in the agency that might have anything on this broad topic. So sometimes having a back and forth conversation about who the key holders of records on that topic, and then more specific terms or phrases can really help reduce an otherwise broad request that ends up as a very expensive request. So I guess that was a statement, but I guess my question to you is, do you think that would be helpful to you to, in some of your requests for information, to more target specific people or specific search terms that would then hopefully lead to a lower cost, which is a win-win for the agency to have, not hundreds of hours of time, and certainly a win for the requestor such as yourself to have a lower cost. Do you think that would be helpful, or have you experienced that trying to go back and forth to narrow in on specific key, smaller number of people and specific search terms?
Well, I've learned to always ask for the FOA contact within a department. But my technical background is as a financial fraud investigator. And so I've learned through many years of experience that if people have something they don't want found, it will never be found. And so I'm in my particular case, I've asked in a variety of ways for some specific information. And through different sources in that one piece of information. And I only got the information because somebody surreptitiously sent it to me without the department's knowledge. And so again, in my situation, it's more of a case where if you don't want something discovered, it doesn't matter how you ask. But I deal with Brenda a lot, so and she knows that. She knows that I ask a lot of questions, and again, even she has had a hard time getting information sometimes. But I do thank her for all her work. Thank you.
Thank you, Eric. Additional questions from committee members? Seeing none, again, thank you very much, Mr. Capron, for being here today, and we appreciate your participation. Thank you. And with that, I would entertain a motion to adjourn.
So moved.
A motion made by Mr. Campbell, seconded by Ms. Clancy. Okay, all those in favor? Thank you all very much for your participation in the full meeting and for all of the work that you've done on all of your subcommittees as well. Did you have a hand up, Eric? Or are you just voting time to go home?
Just voting.
Okay. Thank you very much. And thank you, Peggy and Colleen and everybody else from OPLA. Take care.